Okay, good morning, everybody. This is our second day, and I can see you're all looking very bright-eyed, and we've had a good evening. I thought the museum was just amazing, a wonderful locale for our dinner. I want to just do a few administrative announcements while folks are trickling in. This is the constant reminder that every conference has about program evaluations. They're in your little folders. Please fill them out. I actually personally read them every single year, and each year we've actually learned something to do for the next conference. And that includes, what you liked about this conference, what you didn't like about this conference, including the venue or that you really liked it, panels that you that you really enjoyed, panels that you thought, didn't need to be here. I mean, seriously, we need to know. And also, what I really would like to hear is your ideas for what we should do next. Any suggestions for panels or topics, things like that. So they're in the materials. You can fill them out and hand them in to the desk, and you can do it now, you can do it during the day, but we really need them. I do want to remind folks, if you've got for the travelers for this conference, the panelists, if you've got your travel vouchers with the financial information, you can give them to Mary Claire or Kayla at the desk, and that way you don't have to email, since we're into a program about digital privacy and things like that, your personal details. So this morning we're going to hear from Philip Baker and Pasquale Pistone, which you cannot see his name because we've put professor on top of that. But talk about a really wonderful project, and we've been trying to align three projects. Yesterday you heard from Philip and Lillian who've been working on a project with the International Law Association. And then there's IBFD's project on the Observatory on Taxpayer Rights, and then this conference. So it's a very nice alignment. And then after their panel, I'm going to commandeer this conference for 15 minutes, maybe, and exercise my chair control to do a little bit of a discussion about a project that my office has been working on that I think fits into this, and I didn't think we'd have anything to show for it, but now we do. So I'm taking over for a few minutes. Go ahead.
Thank you very much, Nina, and thanks to all of you for being here and share with us this time. As you can see, we are presenting the work of the Observatory on the Protection of Taxpayers' Rights. This is an initiative that Philip and I are directing. We have decided a couple of years ago to start this project because we felt that there is a need to put the protection of taxpayers' rights on the global agenda. We felt that the idea of having national protection of taxpayers' rights is fine, but since there is a global dimension for international taxation and for tax in general, then it's also important to make sure that we discuss about the remedies that taxpayers have. And we have, as you can see on the slide, we have a link from that slide, which should have been distributed to you yesterday. And we have posted on our webpage at IBFD, free of charge, and so with free access, the annual report for 2018. And that includes a number of national reports that I'll be telling you in a couple of minutes, and also the general report. So I think it's also nice to sort of let the slide on the screen. You should have it, and then you can then see yourself what we are presenting today. Now, the agenda for this presentation starts with information about the observatory, and then we'll go for some selected relevant developments. And the pattern of the selected relevant developments, you will see a plus in green and a minus in red. We are not making this in a judgmental way, but we thought that it would be helpful also for you to understand what type of improvements have taken place in 2018 as compared to the standards that we have established with our general report for the International Fiscal Association in 2015 and what has perhaps changed. And we have decided to give particular emphasis to one specific development, just to give you an idea of the type of information that you can find there. And this is about legal professional privilege overruling, which you find in section 5317 of the annual report for 2018. Then we'll give you this summary and some closing remarks. As Nina has indicated, this project of the Observatory on the Protection of Taxpayers' Rights is linked with other research projects, but the starting point is the IFA 2015 general report that Philip and I have drafted. And the idea is that we put the emphasis on the protection of taxpayers' rights, not only from the perspective of good governance, but also from that of legal remedies. Our goal is to raise the awareness on the links between taxation and human rights, and to make sure that there are reliable data available on what is going on around the world in connection with the protection of taxpayers' rights. So every year we come out with new reports, and as Nina has said, we have teamed up, and the idea is that we present these activities in connection with the taxpayers' rights conferences that Nina organizes. For the whole year, the information stays on our webpage, free of charge, and anyone can access it, and that will be also kept for the following year. So now you can find the information of the previous report and this report. I think it's also important that you understand that when you look at the names of the contributors, some of which are here, and I would like to thank them very much for their support. When you look at the contributors, there will be also some indications about whether they are tax authorities, tax practitioners, or professors, or ombudsman, and that is because we want to make sure that this is done, that the information provided is done in the most transparent way, because sometimes there could be different views. Let's say the judiciary may have different views from tax authorities or tax practitioners, so we want to make sure that everybody knows where the information comes from, and this is to preserve transparency. We have a supervisory council which gives us an oversight of the activities and the consistency, and gives us with our goals, which are to make data available in a non-judgmental way, and gives us the advice. The members of the supervisory council are practitioners, are judges, and there is somebody, as you can see, called Olson, so I think you know who I'm talking about, and she helps us also with her advice, and this is why it's also very nice that we have all this initiative together. The working standards are based on fact reports, so what has happened, but the facts report relate to the categories that Philip and I have drafted in the 2015 general report of the IFA, and that is important also to try and have a consistency, so that we use a kind of common standards in respect of 12 points, which are included in our IFA general report, and these 12 points go through the procedures. So I think this is also meant to facilitate the the reading and the usage also of this set of materials. We rely on a national group of experts, which, as I said, includes 5 main categories. You can see them in the cake now on the slide. And this year we've made it to include 42 countries, including the US for the first time, and we're very grateful to Nina for the support, including China for the first time, and including other countries, as you can see in the map right now. I think it's important also to see that on top of the reports by the National Group of Experts, we have enriched the content of the general report with a sort of introductory session, and also with links as compared to what has happened in the previous years. And I think this is also important. Our goal and ambition is that anyone can use this. Anyone can see what happens in respect of something which is potentially critical in his or her country, and then see how the others have addressed this point, or whether there are issues. I mean, yesterday we heard many interesting things during the first day of this conference, and I'm sure that we all agree on the fact that we share common problems connected with the protection of taxpayers' rights. So it's also useful to look at what happens in other parts of the world. In the field of international taxation, we are seeing this already. So if, for instance, we talk about beneficial ownership, then we look at what happens, with the Canadian courts and now with the European Court of Justice. So we also want to make this happen in connection with the protection of taxpayers' rights. And Philip will now be giving you some information specifically about the legal professional privilege. Philip.
Thank you. We just thought we'd take one example of material from the report and just show you the sorts of things that you can find there. And these are just some examples of developments in the last year from 4 countries in relation to legal professional privilege, attorney-client privilege in the tax realm. I guess in that realm, there are 2 sort of critical questions. One of them is, with regard to tax, does the privilege extend to professionals who are not lawyers? So other tax professionals, accountants, and secondly, what sort of exceptions are there that exist for tax matters? Is tax exceptionalism applied to professional privilege? Just 4 out of actually 10 examples that are contained in the report. Firstly, from Belgium, in January last year, the Supreme Court issued a decision stating that information that had been obtained from a lawyer in breach of client-attorney privilege could nevertheless be used by the revenue authorities despite the breach of privilege. It could be used by them as a basis for a tax assessment. And that case is referenced fully in the report if you wanted to follow up and read the case. Then from Canada, a federal court case, the Atlas Tube Canada case, which concerned the question of whether privilege extended to a non-lawyer. In that case, an accounting firm had prepared a due diligence report. Could that be protected by privilege from the revenue authorities? No, said the Canadian Federal Court. It could be used as a basis again for tax assessment. Kenya, a legislative development here, under the Kenyan Tax Procedure Act, it is specifically provided that the revenue authorities, in obtaining information there, may obtain information that would otherwise be privileged from disclosure. So that gets a sort of negative in our assessment. And finally, an example from Portugal, not an unusual development in Europe, but a development where under anti-money laundering legislation, lawyers are required to report certain transactions, even though those transactions might otherwise be privileged from protection. If I might add a little note here, I teach a course on taxpayers' rights, and I use the reports from the observatory for my students. One of the things they do is they prepare a project, and I ask them either to take a particular country or to take a particular topic, like, say, professional privilege, and prepare a presentation. Saves me from having to do the work. They do the work instead. And I send them off to the observatory in the knowledge that then they can access that information from reporters from country to country. So those of you who are academics, you may find that very useful with your students as well.
Yeah, you can do it as academics, but also you can do it when you have some specific problems. Be you either in the case that you're a tax authority or a practitioner, or belonging to any of the other categories that we have mentioned before. Because the idea is really that this is information that should be reliable and available, and that you can sort of check at any time. Now, Philip and I have decided to make a little tour through the 12 points of the annual report, so that each of you can become also familiar with the structure of the report. The first area is about the identification of the taxpayers the issuing of tax returns and the communication with taxpayers. Philip and I are going through this, but of course, we will not go point by point, but this is just to sort of get you a little bit acquainted with those issues. So for instance, when you look at the pluses of 2018, I would like to draw your attention upon the fourth point, enactment of regulation that strengthened data protection and habeas data. So in 2018, there have been developments concerning the general data protection regulation in the European Union, which have marked a change, a significant improvement as to the protection of data in the European Union. And we could clearly see the evidence of what has happened in the country at the level of changes in the legislation and also in the right to access data and the right of taxpayers to be informed at data that are relevant for them. As you can see, there are pluses and minuses, but I thought about pointing out this specific issue on in respect of the first area. Now, the second area is connected with the issuing of the assessment. And I think that this time I would like to to draw attention upon the third point of the right column, so the minuses, and the problems concerning the cases of inability of the taxpayer to participate in the assessment. And that is something which has taken place in some countries. You can find out yourselves in what country this has been the case, but the idea is you can use the general report because whatever you see in those slides reflects the content of the general report. And if you are interested in some specific points from the general report, you can then go in the actual national reports to find the full reference to that. You will see that there are references to case law and administrative practice. And I think, this is, making it particularly interesting. Now back to you, Philip, for confidentiality.
Okay, just a couple of points to pick up on the area of confidentiality. One that's already been spoken about yesterday. One of the major developments in the last year throughout Europe was the implementation of the General Data Protection Regulation. That regulation applies quite explicitly to tax authorities who are data controllers. And so we've seen authorities adopting policies, procedures to protect the data that they hold on taxpayers. On the negative side, we've seen a little bit of an extension of the development of the last couple of years of countries removing the requirement of judicial authorization before certain information is exchanged. This is particularly true of exchange with other countries, where a number of jurisdictions, Switzerland, the Netherlands, for example, they had judicial procedures that had to be followed before the revenue authorities could supply information in compliance with a request from another country. Under pressure, those countries have removed those safeguards, and that development has unfortunately continued with other countries last year. Back to you.
Now we go to normal audits, that's area 4. So we have differentiated in our general report for the IFA conference in 2015 between methodology used for normal audits and for more intensive audits. And the idea is that there should be a difference because audits have some clear intrusive effect in the sphere of taxpayers, and so there should be some differences. But the issues that we can see from this slide is that there have been some changes connected with the enforcement of the proportionality and the right of being heard. You can see it top left in the on the slide, right below the plus. And I think that this is the one important point is that yesterday I heard several people saying that we are seeing a more mature application of the protection of taxpayers' rights. And in fact, the 2018 reports prove that there is this trend. So the idea that the right of being heard is not just something written on paper, but it's something which is becoming more and more effective. If we go to intensive audits, now you'll see that we have also some issues on both columns. I mean, in most cases, we will have developments on both columns, but you'll see at the end that there are also some cases in which we only have recorded positive developments, which is very encouraging. Philip and I, in our general report, were particularly concerned about the use of seizure and also the fact that in several cases, audits were conducted without court authorization, in particular in cases connected with on-site inspections and cases in which the taxpayer or a business taxpayer was deprived of books and all other he could need for the activity. But now we're seeing that there is an increase there is a trend in increasing court authorization for those very intrusive forms of audits. And this is, for us, something which is particularly welcome, because it is important to have a proportionate reaction to non-compliance, and therefore also when we have serious cases, to the extent that is possible, it is good to involve the judiciary in giving the authorization. When we did the report in 2015, we remember that the best practice was from South Africa at that time, but now we're seeing that this is spreading through. Back to you, Philip.
Just a couple of matters in relation to, first of all, review and appeals, particularly in the context of this conference. Note the development that in a number of countries, it's now possible to appeal a tax authority's decision electronically. Also, in a number of jurisdictions, we've seen measures taken to reduce the length of the procedure and to bring the matter to a more speedy conclusion. Also, issues such as privacy being ensured in hearings. If we turn to sanctions, criminal administrative sanctions, one of the big developments that we've seen again in Europe has been the whole question of ne bis in idem. We all know that a knowledge of Latin is essential for understanding taxpayers' rights. The issue that occurs in pretty much all countries, where if a taxpayer incorrectly completes their tax return, it may be that they are liable to pay the additional tax. They may end up paying an administrative fine, but they may also be subject to criminal sanctions as well. And that raises the possibility of double jeopardy, ne bis in idem, double jeopardy, and the question of how you determine whether or not somebody is facing two penalties for the same conduct. Well, that's been an issue that's been troubling the European Court of Human Rights. There was a decision a couple of years ago in a very memorable case called A and B versus Norway, even I can remember the name of that case, where the court essentially said there's nothing wrong with having two penalties for the same conduct. After all, if you drive too fast, you could end up with a speeding ticket, a criminal fine, and you could have your driving license taken away. There's nothing wrong with multiple penalties, provided that they constitute a single coordinated approach to sanctioning the conduct. Well, that's been working its way through the position in revenue authorities, and they've had to consider whether they need to change the approach they take to administrative penalties, criminal sanctions, to ensure that they are a single coordinated approach. On the question of enforcement of taxes, here just to pick up a minus, and that is we have seen in some countries a growth in the revenue authorities having direct access to, for example, bank accounts without a requirement of prior judicial authorization. So they can just go to the bank account and take money out of it, rather than the same attitude that my children have to my bank account. Cross-border procedures, we've spoken a little bit about this yesterday, particularly the question of the exchange of information and the automatic exchange of financial account information for tax purposes, where we have seen, on the one hand, data protection legislation improving. On the other hand, still a major problem that large amounts of data are being exchanged between countries with very doubtful safeguards being provided for that. I think it's now back to you, Pasquale, for the last. Oh no, it's one more topic.
One
for me.
more, yeah.
One more for me, actually. Legislation. I guess the interesting issue here really is a question of retrospective legislation, where when we surveyed this a couple of years ago, the world sort of broke into three parts. One part of the world, countries that ban retrospective tax legislation. Another part, countries that allow it, but in very, very limited circumstances. And then another part of the world where retrospective legislation is relatively common. What we've seen as a negative element here is certain challenges to retrospective legislation being brought before courts, and the courts in those countries that practice that accepting that, but a little sort of only a spoiler alert, but there are issues arising, particularly from retrospective legislation in India, that are the topic of international arbitrations. And there will be some interesting decisions coming out in the next couple of months on the question of retrospective tax legislation in India. So something to watch out for.
Yes, and I think this also gives you an idea of the fact that this observatory is just monitoring whatever happens in the world on issues connected with the protection of taxpayers' rights. So I think it's something that you can just easily use and rely on that. Now, this is one of the pleasant areas, the one in which we only have content on the left column and nothing on the right column. But if you look, for instance, at the third point, principle of legitimate expectation, then you can recall some of the points that I was making when Alice and Rick were making their presentation yesterday. So this growing importance of the protection of legitimate expectation and the protection of taxpayers acting in good faith and relying on information provided or guidance provided by tax authorities. Now, of course, this doesn't mean, this is just an indicator of a trend, but this doesn't really mean that you can invoke legitimate expectation when you have this guidance. The matter is a bit more complicated because you have to understand whether the guidance was in fact in line with what tax authorities had to give. So in some cases, there are some limits to that, but still it's important to say that no matter what tax authorities write in terms of the fact that guidance should not be relied upon, it still have some effects in some countries of the world. So it could be also interesting for you to have a look at this, since it's a point that popped up yesterday during the presentation of Alice and Rick. The 12th area is on the institutional framework for protection of taxpayers' rights. And I think that I'm sure Nina will be delighted to hear about that there is a growing trend on taxpayers' bills of rights and their effective use in the protection of taxpayers' rights. So I think this is something which many years ago simply did not exist. In some countries, taxpayers' rights have a mere declaratory nature. In some other countries, they are used to enhance the protection of taxpayers' rights. I think, in general terms, knowing in a transparent way what the rights are helps establishing a dialogue, a constructive dialogue. And also with this observatory and the protection of taxpayers' rights, we have never thought about using this for contentious purposes. We just want to provide data, reliable data that can be used to build up awareness and trust in the relationship between taxpayers. And we are very happy that we can team up with Nina, her projects, involve her directly in our activities, and also having research conducted in connection with these data. And research is, for instance, this project of the International Law Association that we have already mentioned. But in a couple of weeks from now, there will also be the Conference of the European Association of Tax Law Professors on tax procedures. So it's all nicely contributing to give taxpayers' rights a global dimension. And this brings us to the end of our presentation, I would like to to devote the last words to thank all of you who have contributed to the observatory, to reassure you that this is something which is going to be for many more years, and we will be delighted if you could all use. But my final words are also to thank Carlos Huefe, who's here, and he's been putting a tremendous effort into this, and I think, it's nice also to have the last words for him. Thank you very much.